Hello everyone, so I'm welcoming you again. So in this video we are going to discuss about the Article 20 of the Indian Constitution that basically give protection in respect to conviction for an offense. Okay, so if suppose there was an individual, okay, so prima facie he will be treated as innocent, okay? But if there are some allegations are put, then he will be accused, and accused can be what? Can be arrested or detained. That is, he can be what? There can be arrest or detention. So it can be what? A police custody, and it can be what? Judicial custody. Now the protection from arrest and detention are being dealt under what? Under Article 22 of the Indian Constitution. Okay, that we will see in the later videos. Now then, there after the police or judicial custody, whichever may be the case, there will be what? A trial. Now after the trial there will be a judgment, and you can be what? You can be acquittal, that is you are innocent, and you can be convicted, that is you found culprit of the offense or allegations. So the protection under Article 20 is giving to whom? To person who is convicted. So under Article 20 it deals with conviction. Okay, that is the protection in respect of conviction for offense. So it basically what? The purpose is to protect individual against arbitrary criminal prosecutions and to ensure fairness in criminal justice. Now it was available to whom? To citizens as well as to non-citizens, that is to any person, citizen as well as non-citizens. Now there are basically three clauses. Okay, the clauses are, you can see them. The clauses are like the clause 1 that talk about the no person shall be convicted except for the violation of law in force at the time of commission of the act. That is, a person can be punished only for an act that was already an offense when committed. Okay, like the legislature cannot retrospectively create a new criminal offense and retrospectively increase punishment. You cannot. That is, that there should be no retrospective application of a law. And if you see, like similarly, if you see the clause 2, that basically gives what? The protection against double jeopardy. That means that no person shall be prosecuted or punished for the same offense more than once. So like for example, like the person is convicted or punished for theft, okay, then it cannot again be prosecuted and punished for the same theft. Okay, मतलब simple example से समझे ना. Like suppose a person convicted and punished for theft cannot again be prosecuted or punished for the same theft. That means suppose आपने मेरे घर पे चोरी करी, ठीक है, आपने मेरे घर पे चोरी कर ली, आपने मेरे घर में चोरी की, ठीक है, क्या हुआ? आप कन्विक्ट हो गए और आपको पनिशमेंट मिल गई इस थेफ्ट के लिए. किसके लिए? पनिश्ड फॉर थेफ्ट. नाउ अब दोबारा सेम थेफ्ट के लिए, जो ये थेफ्ट जो आपने यहाँ चोरी करी है, उसके लिए दोबारा मैं आपको प्रोसिक्यूटर पनिश नहीं करवा सकता, नहीं कर सकता कोई भी, ठीक है. बट अगर आप दोबारा आके फिर से चोरी करते हो तो फिर वो एक डिफरेंट है. उसके लिए आप दोबारा कन्विक्ट हो सकते हो और पनिश्ड किए जा सकते हो फॉर थेफ्ट. ये थेफ्ट 1 है ना. लाइक थेफ्ट 1 आपने मेरे घर पे की, फिर आपने थेफ्ट 2 करी मेरे घर पे, तो इस थेफ्ट 1 के लिए आपको एक बार कन्विक्ट हो गए और पनिश्ड हो गए, और तो आपको दोबारा इसके लिए आपको कन्विक्ट और पनिशमेंट नहीं मिल सकती. मतलब देयर शुड बी नो डबल jeopardy. ओके, नाउ इसे हटा देते हैं. द क्लॉज 3 दैट बेसिकली गिव्स प्रोटेक्शन अगेंस्ट सेल्फ इंक्रिमिनेशन. दैट इज दैट नो पर्सन एक्यूज्ड ऑफ एन ऑफेंस शैल बी compelled to be witness against himself. So it's sort of the objective here is to prevent what? Coercive extraction of evidences. So there are three essential conditions. That is, a person must be accused of an offense, and there must be a compulsion, and compulsion must force him to give evidence against himself. Okay, a compulsion can be what? A compulsion can be physical force, threat, pressure, or coercion, है ना. So basically what is prohibited here? The prohibition is upon what? Like the forced testimony, forced disclosure, है ना. आप ये नहीं करवा सकते. बट इसका मतलब ये नहीं है कि आप अपने फिंगरप्रिंट्स नहीं देंगे, आप अपनी हैंड राइटिंग सैंपल्स नहीं देंगे, आप अपने सिग्नेचर सैंपल्स नहीं देंगे, वॉइस, ब्लड, DNA सैंपल्स, इन ये सब ले सकती है पुलिस. बट आपको वो एक पिक्चरों में दिखाया जाता है वो 3rd डिग्री दे के, और वो सब नहीं कर सकती है ना. सो बेसिकली नो सेल्फ इंक्रिमिनेशन मीन्स दैट इज इट गिव्स यू द राइट टू रिमेन साइलेंस. नाउ वी विल सी each clause one by one in detail. Okay, so let's start with our clause 1, that is Article 20 clause 1. So Article 20 clause 1 that says that there should be no ex-post facto. That is, the ex-post facto means what? There should be no backdated application of a law. So that no retrospective application of law, and no law can be applied from backdated. That is doctrine of prospective overruling. Okay. Now the doctrine of retrospective ruling, that is what? Retrospective means backdated effect. So in criminal cases there can be applied from back. So Suppose a person, Mr. X, done a crime in 2025, and at that time it was not treated as what? At that time there was no punishment, okay, for the crime. Now later there was amendment in the law, and for the same crime in 2026 the punishment is what? Is 5 years of imprisonment. But you cannot punish Mr. X for crime committed in 2025 because at that time there was no punishment for the crime. And that this is the principle of what we called as doctrine of what? Prospective overruling, that there should be no retrospective application of law. But there can be a backdated effect, like for example, if you've seen like the GST, which was in July 1st of July 2070, but it has a backdated effect from what? 1st of April 2000. Okay, so in criminal cases there should be no retrospective application of law, and no law can be applied from backdated. But in civil cases they can be applicable from backdated. For example, we have seen the GST. Okay, now there was few cases like Kedarnath versus State of Bengal, where what? A crime where the Supreme Court said that what? That there should be no application of law in what? In criminal cases. Okay, similarly there was another case, that is the Ratanlal versus State of Rajasthan, where what happened? Ratanlal committed a crime, okay, and the punishment for the crime is what? 7-year punishment. But in 1970s there was amendment, and for the same offense or crime the maximum punishment was reduced to what? 2 years. Okay, so the Supreme Court released Ratanlal, and basically it said that ex-post facto allowed in criminal cases or laws, but if only punishment of convict reduced, only the ex-post facto allowed in criminal case. Okay, then a very famous case, that is the Nirvaya case, where there are 6 convicts. The 2 committed suicide, 3 were giving punishment, that is hanged till death, and the minor. So at that time the juvenile is someone who is less than 18 years of age. Okay, and there is what? Juvenile Justice Act, that gives maximum punishment of 3 years only, and that too in what? Judicial custody. But later it was amended, and the definition of juvenile is changed, and now if somebody is less than 16 he will be treated as juvenile. So there is no retro effect from back, that is backdated. निर्भया केस, सो बेसिकली ये तो सबको ही पता ही होगा निर्भया केस में क्या हुआ था। और बेसिकली 6 कन्विक्ट थे उसमें, उस केस में उन्होंने तो सुसाइड कर लिया था, और 3 को हैंड टिल डेथ की सेंटेंस मिल गई थी। और उनमें से जो एक माइनर था जो कि जुवेनाइल था उस टाइम पे, जब उसने वो क्राइम कमिटेड किया, जब उसने वो क्राइम किया था तो उस टाइम पे जुवेनाइल था। तो देयर वाज अ जुवेनाइल जस्टिस एक्ट, उसके अंडर ये डेफिनेशन थी कि जो भी मतलब अगर कोई 18 साल या 18 साल से कम होगा तो वो जुवेनाइल होगा, तो उसे जुवेनाइल की तरह ट्रीट किया जाएगा। और उसमें जो मैक्सिमम पनिशमेंट थी वो 3 साल की थी, इसलिए जो माइनर था उसको बस 3 साल की पनिशमेंट मिली थी, और उसके बाद उसको रिलीज कर दिया गया था। तो उसके बाद क्या हुआ? ह्यू क्राई हो गई थी ना यार पूरे सोसाइटी में, क्योंकि वो इतना घटिया और घिनौना मतलब क्राइम ही किया था उन लोगों ने, ठीक है। और उसके बाद लोगों के कुछ जजमेंट्स, मतलब हर जगह कुछ लोगों के जजमेंट नहीं करने चाहिए, बट लोगों के जजमेंट्स भी थे उसके ऊपर, उस चीज़ों के ऊपर बहुत सारे। इवन तो अगर उसके लॉयर को भी देखोगे, उसके अगर बहुत सारे इंटरव्यूज दिले हैं, अगर आपने देखे होंगे तो, है ना। तो उसके बाद क्या हुआ कि इस केस में इस लॉ में अमेंडमेंट हुई, इस एक्ट में, और उसके बाद डेफिनेशन ऑफ जुवेनाइल को चेंज किया गया, और उसमें बोला गया कि अब कोई अगर फ्रॉम नाउ ऑनवर्ड्स जो भी 16 साल के अंडर होगा वो जुवेनाइल होगा, ठीक है। बट ये क्या था? एक क्रिमिनल ऑफेंस इसने कमिटेड किया था, ठीक है। तो और हमारी लॉ में क्या है? नो रेट्रोस्पेक्टिव एप्लीकेशन ऑफ लॉ, मतलब आप बैक डेटेड इफेक्ट से आप उसे प्रोसिक्यूट नहीं कर सकते, पनिश नहीं कर सकते। तो इसलिए इसको 3 साल बाद छोड़ दिया गया था, ये रिलीज हो गया था जेल से, है ना। इसमें सो बेसिकली आर्टिकल 20 क्लॉज 1 में क्या है? यही तो लिखा है कि दैट देयर शुड बी नो पर्सन शैल बी कन्विक्टेड ऑफ एन ऑफेंस एक्सेप्ट फॉर वायलेशन ऑफ लॉ इन फोर्स एट अ टाइम ऑफ कमिटमेंट ऑफ द एक्ट, बट an act can be punished only if it was already an offense when committed. Or criminal laws cannot operate backwards. A legislature cannot create a new crime retrospectively. So basically यहाँ एक principle चलता है, that is what? No crime without law. So समझ में आ गया होगा आप लोगों के ये पूरा आर्टिकल, that is what? 2 पार्ट में है। पहला पार्ट क्या बोलता है? that no retrospective crime, और सेकंड क्या बोलता है? no retro harsher punishment, ठीक है। Now we will read about article 20 clause 2, okay, that gives you a sort of protection against double jeopardy. So where the constitution text said that no person shall be prosecuted or punished for the same offense more than once. Basically, the objective is to protect individual from repeated criminal trials and prevent any sort of harassment by the state. It is to ensure what? A safeguard to personal liberty and promote fairness in criminal justice. So the doctrine of double jeopardy. There are some essential conditions. For example, essential conditions. So there are 3 essential conditions: 1, 2, and 3. The first is there must be a prosecution. The second is there must be a punishment. The third is what? The prosecution and punishment must be for the same offense. What? Prosecution and punishment must be for the same offense. Only when all 3 exist, then only the Article 20 Clause 2 become applicable. Okay, like for example, suppose a person is prosecuted before a court. Okay, and the court now suppose a person is prosecuted before a court. Okay, and the court reach a final decision and person is punished, and he is punished. Now what happened? A state attempts another prosecution for the same offense. Then the constitution prohibits second prosecution and punishment. Okay, got it? But what is not prohibited here is that like departmental inquiry is not prosecution, is not a prosecution. Okay, तो अगर आपका एक क्रिमिनल ट्रायल चल रहा है और उसी के दौरान अगर आपको आपके जो डिपार्टमेंट है उसकी इंक्वायरी चल रही है, तो डिपार्टमेंट इंक्वायरी इज नॉट अ प्रोसिक्यूशन, है ना. और जो सिविल प्रोसीडिंग्स हैं और क्रिमिनल प्रोसीडिंग है वो क्या है, एक डिफरेंट नेचर ऑफ प्रोसीडिंग है, तो दे आर ऑल्सो नॉट प्रोहिबिटेड. लाइक फॉर एग्जाम्पल, एक एग्जाम्पल लेते हैं, जैसे एक गवर्नमेंट एम्प्लॉय है, व्हाट अ गवर्नमेंट एम्प्लॉय जो कि ब्राइब लेता है. ठीक है, अब इस पर क्या होता है कि डिपार्टमेंट इंक्वायरी स्टार्ट हो जाती है, डिपार्टमेंटल इंक्वायरी हो जाती है और एम्प्लॉय को डिसमिस कर दिया जाता है, इसको डिसमिस किया जाता है. और बाद में क्या होता है कि जो क्रिमिनल कोर्ट लेटर ट्राइज हिम बिकॉज ही हैज टेकन ब्राइब, दैट इज एन क्रिमिनल ऑफेंस. So Article 20 Clause 2 not violated because departmental inquiry is not a criminal prosecution. Okay, like for example, there was one case, that is Maqbool Hussain Alam versus State of Bombay. Okay, you can read about this case. That case is basically related to Article 20 Clause 2, where basically इसमें हुआ क्या था कि जो मकबूल हुसैन आलम जी हैं वो गोल्ड लेके इंडिया में आ गए थे, और हुआ क्या, जो कस्टम अथॉरिटीज़ ने इनका गोल्ड कन्फिस्केट कर लिया और सीज कर लिया. ठीक है, द गोल्ड वॉज कन्फिस्केटेड बाय द कस्टम डिपार्टमेंट. सब्सिक्वेंटली क्या हुआ, अ क्रिमिनल प्रोसीडिंग्स वर इनिशिएटेड अगेंस्ट हिम, क्रिमिनल प्रोसीडिंग्स अंडर द फॉरेन एक्सचेंज रेगुलेशंस. ओके, तो क्रिमिनल प्रोसीडिंग भी इनके ऊपर लग गई, इनके ऊपर सब्सिक्वेंटली क्रिमिनल प्रोसीडिंग भी इनिशिएट हो गई. ही आर्ग्यूड दैट द क्रिमिनल प्रोसिक्यूशंस violates what Article 20 Clause 2 because he had already been punished by the custom authorities. ठीक है, क्योंकि आर्टिकल 20 क्लॉज 2 में क्या बोला जाता है, दैट नो पर्सन शैल बी प्रोसिक्यूटेड और पनिश्ड फॉर द सेम ऑफेंस मोर देन वन. तो इशू ये था कि जो गोल्ड इनका जो कन्फिस्केट कर दिया गया है कस्टम अथॉरिटीज़ के द्वारा, वो कह रहे थे जो मेरा गोल्ड है जो मैं लेके आया उसे तो कस्टम अथॉरिटीज़ ने ले लिया है, उसे तो कन्फिस्केट कर लिया है, तो अब ये सब्सिक्वेंट क्रिमिनल ट्रायल मेरे ऊपर लगाए जा रहे हैं, ये आर्टिकल 20 Clause 2 को वायलेट कर रहे हैं. तो सुप्रीम कोर्ट ने इसमें जजमेंट में बोला गया था कि दैट कि जो कस्टम अथॉरिटीज़ आर एडमिनिस्ट्रेटिव और क्वासी जुडिशियल अथॉरिटी, नॉट क्रिमिनल कोर्ट्स, एंड confiscation of good by custom authority is not a prosecution before a court of law. Therefore, the confiscation do not amount to what? A prosecution and punishment within the meaning of Article 20 Clause 2. Then the subsequent criminal prosecution was valid. समझ में आया? तो कोर्ट ने इसको भी valid हो गया था. Now we will read about the Article 20 Clause 3. So now Article 20 Clause 3 that basically gives you protection against self-incrimination. That is that no person accused of an offence shall be compelled to be witness against himself. Now the basic object here is what? To prevent any sort of coercive interrogations or torture or forced confessions that you have seen in movies like 3D torture or sort of thing, है ना. Like suppose करो, so the core principle here is what? It basically prohibits what? It basically prohibits self-incrimination. The accused person himself, that is, the no person can be forced to provide evidence that may lead to his own conviction. So there are also some conditions. There are some essential conditions. Some essential conditions that are: the person must be accused, that is, some formal accusations must exist. Second, there must be some compulsion. A compulsion can be what? A physical force, a sort of threat, intimidation or coercion. And third is what? A compulsion must make him a witness against himself, that is, the oral testimony or written confession or answer to incriminating questions or disclosure of personal knowledge sort of things, है ना. So all three conditions are necessary. So here what is prohibited? The prohibition is upon what? Forced confession, force admission of guilt. कि मतलब उसे आप forcefully आप उसे torture करके उससे बोल रहे हो कि भाई ये क्राइम तूने किया है, ठीक है, इसे मान ले, और आप इंटेरोगेशन के टाइम पे उसे इंटिमिडेट कर रहे हो और उससे आंसर ज़बरदस्ती निकलवा रहे हो, या एनी सॉर्ट ऑफ फोर्स जो 3D टॉर्चर कहते हैं उसको, आप ऐसा कुछ भी नहीं कर सकते. मतलब आप, सो हियर अ पर्सन कैन व्हाट, he can remain silent, that he has the right to remain silent, that he has right against what? A forced testimony, he has right against forced confession, he was protected during investigation as well as trial. But that no self-incrimination doesn't mean that you're not prohibited from giving your fingerprints, thumb impression और सिग्नेचर सैंपल्स, वॉइस सैंपल्स, फोटोग्राफ, ब्लड सैंपल्स, DNA सैंपल्स, मेडिकल एग्जामिनेशन. आप इन चीज़ों के लिए मना नहीं कर सकते, समझ रहे हो क्यों? क्योंकि यार ये एक दे आर दी फिजिकल एविडेंसेस. ओके, ये आपकी टेस्टिमनी एविडेंसेस नहीं है. और लाइक सपोज एक पर्सन है, ये पुलिस कस्टडी में है, ठीक है, और पुलिस कस्टडी में इन्होंने कन्फेस किया कुछ, तो विल इट बी एज एविडेंस, और या कोर्ट में जाके ये जो भाई साहब जो भी बोलेंगे, कोर्ट में जो कन्फेस करेंगे वो एविडेंस के तौर पे लिया जाएगा. बेसिकली होता क्या ना, द कन्फेशन इन अ पुलिस कस्टडी कैन बी एक्सेप्टेड एज एविडेंस, बट if this is the only evidence that he has confessed his crime, then he will not be convicted. There is no conviction. Okay, कोर्ट के अंदर जो कन्फेशन होगा उसे आप एविडेंस के तौर पे ले सकते हो, बट अगर आप पुलिस कस्टडी में कोई भी कन्फेशन करते हो या आपको करवाया जाता है, और अगर वो आपका जो कन्फेशन है वो ही अकेला एक एविडेंस है और उसे मतलब जस्टिफाई करने के लिए और फैक्ट और एविडेंसेस नहीं है, तो फिर आपको कन्विक्ट नहीं करा जा सकता, ठीक है. सो द केस कथकालू वर्सेस स्टेट ऑफ बॉम्बे, इन विच द एक्यूज्ड Kalu was required by the police to provide what? The handwritten samples, signature specimen or thumb impressions. So basically he argued that compiling him to provide these amounting him to forcing himself to be witness against himself. That is, इसने बोला कि ये सब मैं दूंगा तो it basically violate what? Violate my Article 20 Clause 3. So then the judgment, in this case the Supreme Court said that under Article 20 Clause 3, there was protection that it basically protect an accused only from being compelled to provide what? A protection was given to what? A personal testimony based on his knowledge. Personal testimony based on his knowledge. But the physical evidences, that is what? The fingerprints, handwriting sample, signature, footprints, photography are what? Physical evidences, and these are not testimony evidences. Therefore, compelling an accused to provide such physical evidence does not violate Article 20 Clause 3. So under Article 20 Clause 3, no self-incrimination gives you the protection not to confess the crime, that is personal testimony, but it does not protect you from giving the specimens, that is for scientific studies like blood, urine, saliva, etc. Okay, similarly there was another case, that is Selvi versus State of Karnataka. So basically in Selvi versus State of Karnataka, so the investigation agencies were using what? Scientific technologies like narco analysis and the polygraphy test or brain mapping. So the question before the court was that whether these tests could be conducted on an accused person without consent. So then the Supreme Court in this case held that no person can be forcefully subjected to narco or poly or brain mapping. It basically laid down that conducting such tests without consent violates Article 20 Clause 3 because the response obtained are testimonies in nature. Okay, and the forced administration of these techniques are infringes what? The personal liberty or mental privacy protected under Article 21. So under Article 20 Clause 3, there was protection to protect an accused from being compelled to provide testimony evidences against himself. So here the Supreme Court said that, Supreme Court basically said no. That is, Supreme Court said that these design instruments cannot be rational, but these can be allowed as supporting evidence if the accused allow or give his consent in written. Okay, now we have done with what? We have done with Article 20 Clause 1, 2 and 3. And I think you all have, thank you for watching the video, and please do like and comment and share, and if you have any feedback then please do comment. Bye.